Beginning a discussion on civil liberties and civil rights as protected by the United States Constitution and by extension by the Fourth Amendment protects states' citizens. Civil liberties are those liberties that are important within a democracy to make sure that people have the right to freely express their ideas and to read those ideas within the media, the right to freely assemble, and so forth. So those civil liberties are freedoms of expression, your freedoms of speech, press, religion, petition, and assembly, and freedom from arbitrary arrest. The Fourth, Fifth, and Sixth Amendments are collectively called the rights of the accused, that government cannot search your property without a warrant, that you have a right to face your accusers in court, so forth. Civil rights are citizenship rights, your right to vote within a democracy, and most importantly, the freedom from unlawful discrimination, keeping the government from just arbitrarily and capriciously finding reasons to discriminate against you and your behavior based upon your religion, your creed, your religion, the color of your skin, your race. Those would be considered to be unlawful discrimination. The Bill of Rights, the first 10 amendments of the Constitution, are incorporated, and as a result, the states have to abide by the Bill of Rights and what's called selective incorporation, which you can see on page 157 in your text. Because originally, only the United States Constitution was only to protect citizens from the federal government. But as time went on, and by 1900, there were more and more of the Bill of Rights, which the 14th Amendment says that no state can deny to its citizens the rights that they have under the Constitution. They've been incorporated and applied to the states. So therefore, due process and equal protection of the laws applies to the national government and to the state governments. Your freedoms of expression, peace, press, religion, petition, assembly, speech. The preferred position is that a right of free expression is more important than other rights. So given a choice between a person's right of free expression and some other right they may have to be involved in some other kind of behavior, it's always going to come down on the side of free expression. Again, many cases we may not like what people say, we may not like the religion that they have, but they have a right to that free expression. And another important point is no prior restraint, particularly in regards to press. Government cannot restrain or censor speech and press, even though punishment for libel or obscenity is allowed after the fact. In other words, the government cannot decide before something is said or something is published that it may indeed be libelous, slanderous, obscene, and so forth. Only after the behavior has taken place can government decide whether or not a law was broken. Imminent danger. Shank versus U.S. in 1917 said Justice Alvar Wendell Holmes said that no freedom of speech would allow somebody to cry fire in a crowded movie theater. That would be a clear and present danger to those behaviors which the government has a right to censor or to keep from happening. There is no such thing as absolute freedoms of speech, press, religion, petition, and assembly. Government must remain neutral to all groups exercising expression. So you may have a neo-Nazi group which may be protesting in a Jewish neighborhood. You're going to find the police protecting the rights of a neo-Nazi group to peaceably assemble. Laws forbidding a form of expression must have a clear definition. They have to be clear. Government must use least intrusive means to restrict expression. In other words, they can't come down on with a heavy hammer. They have to find a way to have the least amount of censorship as possible, but still allow everybody to express themselves in a peaceful manner. Exceptions to protected expression can include slander. Don't have a right to say untruths about someone or something, but what you have to prove in a court of law is that you actually intended to harm somebody. Libel is printing an untruth about someone or something, but the courts have decided that public citizens, actors, actresses, politicians are so much in the public eye, and they take into account that they're going to be um, lies are going to be told about them, that it's very difficult to prove libel in regards to public citizens. Illegal actions with a political message. You cannot simply decide that, for example, you cannot carry a sign saying, "I'd like to kill the President of the United States." That's an illegal act. And even though it may have a political message, fighting words are those things that you can say something that would so incense somebody that their natural reaction is violence. Fighting words are not protected by the Constitution. And obscenity. In Miller versus California, the courts decided that local governments can decide what is obscene in their community. And as a result, that there are certain things that you are not going to be allowed to publish or view in certain communities based upon community standards, that you could be arrested for obscenity.